Hello everyone, this is Madhuri, Associate Professor, Department of Law, Padmavati University. Today we are going to look on labor laws. Overview on labor laws we can have it. The table of contents we can see: Equal Remuneration Act 1976, Maternity Benefit Act, Workmen's Compensation Act 1923, Payment of Gratuity Act 1972, Trade Union Act 1926, and Industrial Dispute Act 1947, and at the same time Factories Act 1948. Let's see what is the labor laws. Labor laws and employment laws have been essentially derived from socialist republic state. Labor and employee laws are quite important as they give structure on the workplace. Both employees and at the same time employers are the responsible in some cases. Also outline the particular ways of federal regulations in order to give both parties directions necessary for resolving a particular workmen's or workplace conflicts. The objectives of this particular labor law: protecting the workmen's rights, ensuring safe and healthy working conditions, promoting fair wages, and preventing exploitation. Labor legislation is used to cover all laws which has enacted employees and non-employment of a particular wages and working condition, industrial design, social security, and welfare of the people. Equal Remuneration Act 1976 speaks about equal pay for equal work. It is not a fundamental right but a constitutional right. Equal remuneration for men and women is the right of an employee without any qualification. The Act for the Equal Remuneration Act 1976 was enacted to companies with the provisions of directive principles of state policies under Article 39, and the objective we can say: promotion of a discrimination on the grounds of sex against women in the matter of employment, to provide increasing opportunity to women. Silent features of the particular act we can talk about: central legislation and applies to the whole India, and it also applies to all workers even which is engaged on the particular way of a few day. The Ministry of the Labour and the Central Advisory Committee responsible for this enforcement of this act. And Maternity Benefit Act stands 1961. Here the particular act speaks about employment of a woman at the time of her maternity. It entails women employment and fully paid wages, including her absence during her absence from the work to take care of a child. This act speaks establishment of employing 10 or more employees when there. And here this section, and at the same time the act speaks duration of leave, job protection, financial benefits. Workmen's Compensation 1923 speaks about a first social security measures undertaken in India to provide workmen and their dependents relieving under the particular injury by accident resulting in either death or disability. The employer is liable in certain circumstances for the injury caused to his workers, even when he is away from the premises at the time of an accident. This act also speaks and applies to factories, mines, plantations, transport establishment, construction works, railways, and other hazards employees and occupations, and other specified schedule part 2. According to this theory, notional extension of an employer's and a fixation employment extension is a presumptive or imaginary extension of a particular and exploiting working time under this particular way also should be taken place. And there are certain kind of gratuity acts we can see under 1972. We all must be heard of gratuity, which means a sum of money that is paid to an employer at the end of a service. So in order to eligible for the payment of gratuity, the minimum term of a particular employee must be 5 years in India. That is governed by the Payment of a Gratuity Act 1972. This act laid down the particular guarantee standards pattern of gratuity payments to the particular employees, notions which is to be treated employees organizations with a branch in multiple states differently when they may be required to transfer from one state to another state of the service sectors or service requirements. And you can see some of the case laws in that: Independent School Federation versus Union of India 2022, and where the Jammu and Kashmir was exempted before 2019, it was amended to India to extend to the whole India. Trade Union Act 1926 speaks about a particular union, a group of workers who strive to help workers on issues relating to the fairness of pay, good working environment, hours of the work, and at the same time other benefits which is to be taken. So definition part, you can see trade union means a combination whether temporary or the permanent regulating relations between workmen and workmen employees. Trade Union Act 1926 also speaks about 33 sections and the 5 chapters, and here section 4 to 9 deals with the procedure of a registration of a trade union, section 15 to 16 about general funds, and the duties and liabilities and the regulations also should be taken. The Industrial Dispute Act 1947 speaks about the particular activities of legislations in India, disputes between an employer and an employees, and at the same time, April 1st, 1947, it has come into the force and it contains 46 sections and 13 chapters. The main objective of this particular Industrial Dispute Act is to provide a legal framework for the preventions and settlement of a particular industrial disputes. It aims to promote harmonious relation between the employers and an employee. Section 2, Section 2K and 2 clearly gives you an definition parts of layoff, lockdown and so on. And lockout also we can see, and chapter 6 gives you a particular picture of special provisions, chapter 7 penalties, and chapter 8 gives you the particular ways, powers to make rules, repeal and savings and temporaries and so on. Penalties also we just come under labor practices imprisonment for the 6 months with the fine of 3,000, and illegal strikes and lockdowns or any kind of lockouts when they make it out, imprisonment for the 1 month or fine up to 1,000 or both, or it may be extended to the particular grievance of the particular case. Closure without notice, imprisonment of the 6 months within a 5,000 and all. Factories Act speaks about 1948. Ravi Sharma versus State of Rajasthan 1993 speaks about. Then the Bhopal Treasury case 1984 is a famous case, public awareness of the factors, pollution and risks, necessitating the government actions to allow a particular legislation amendments. And this act has been replaced by Occupational Safety, Health and Workmen Conditions Code 2020. And this comes under the definition of Section 2M of the Factories Act 1948. Major contents we can see of the particular primary health, inspective staff, health, safety, welfare, grievance and all kind of special provisions will be taken according to that. And amendment also we can just take it out 1954, 76, 87 and so on. Thank you all.